Good afternoon, everybody. Welcome to the session on the Family Solutions Initiative, Reframing Support for Families Following Parental Separation. There's a few housekeeping just to start with. If you have a question that you would like the speaker to answer during the webinar, you can ask this by using the Q&A facility within Zoom. If you'd like to speak it to Karen at the end of the session, you can request this by using the raise hand function. And this webinar will be recorded and is available to members after the event. My name is John Hutton Attenborough, and I work for HFS Milbourne. I'm sure some of you already know the firm, but just for those who don't, we've been in business since 1986, and as a financial advisory wealth management firm, we look after private clients, employee benefits, and more recently, following the acquisition of HFS Milbourne by Tilney, Smith & Williamson, we can also offer professional services, and I'll touch on that a little bit in a moment. We're fully FCA regulated to provide financial planning, investment management, and while we're in inverted commas titled restricted, we still operate whole of market in every area of advice that we participate in. Next slide, please, Helen. We've had a good relationship with law firms throughout Surrey, Guildford and beyond. Last year, we probably interacted and engaged with 39 different firms, either within family law, private clients. We've got resolution and STEP accredited members. I had the solo qualification. We sponsored the Surrey Law Society for many years, and also more recently, Guildford Chambers. We introduced something called the 7-step guide to pension and divorce, which goes through all of the various processes of pensions and divorce and financial matters. If you'd like a copy of this, then please ask Helen through the chat function, or email her directly, or even do the chat to me, and I can do send you a copy of that. Final slide, Helen. As I say, we were acquired by Tilney Smith & Williamson last year, and that's created a business for us. We now manage just short of £55 billion worth of money for our clients. There's 3,000 members of staff compared to the 32 that we had at HFS, 265 qualified financial planners. And then the Smith & Williamson side of things has also allowed us to do more professional services. And this is particularly useful, I think, potentially for you. We have a chap called Adam Smith who specializes in US matters, so tax matters, particularly relating to divorce situations. So if that's something that comes up and crops across your desk at some point, then please get in contact with me and I'll be able to introduce you to Adam and get him involved in helping you. Today's session is the president of the family division, Sir Andrew McFarlane, said of the Family Solutions Group report, What About Me? Reframing Support for Families Following Parenting Separation, that this report brings together the various lines of thinking of recent years aimed at finding a better way to achieve good co-parenting between separated parents. It's an important and impressive document, a real page turner. Karen Barham is a member of the FSG, and her proposal for a new Part 3 FPR Protocol is one of the recommendations of the report. And this our session will cover the key recommendations of the report, the development of her Surrey Initiative to a national initiative, and other significant changes in the field of family law, both in children and financial remedy matters, as the focus inevitably moves to out-of-court options with costs and other sanctions for those that do not adapt to the changing landscape. Karen joined Moore Barlow LLP in 2006, bringing considerable knowledge and experience as a family lawyer, having specialised in this area for over 30 years. So can I pass you over to Karen now to go through today's session? Thank you.
John, thank you. Thank you for Adam with his American connections. And thank you also for highlighting their SOLA, the Society for Later Life Advisors, which I'd never heard of. So thank you for that, and certainly for all your support. Colleagues, afternoon to you. I have probably 50 minutes or so to canter through a great deal of material, but I'd like to leave time for a discussion, questions and answers. And John, again, thank you. People can put questions in the Q&A. And we've already had a question in advance about how far and what's the traction of this initiative nationally. But I think we've got a group of us here so that we could have some live chat, and I certainly would like to leave time for that. These slides have been prepared and used variously up and down the country in terms of this initiative and the FSG work. And I've got some updated figures as we go. But essentially, I'm going to speak for the first half about the FSG recommendations, and then particularly about the out-of-court, the pre-court and the out-of-court space. The President has made no secret of the fact that of the remaining, I think about 2 3/4 years he has left in post, that if all he manages to do, he wishes to implement the recommendations that we made in the FSG report. We know the court system is wrong for many of these families. The system is on its knees, and notwithstanding the previous valiant attempts, which I've summarised here, the rush to court, particularly for litigants in parents and litigants in person and parents, has perhaps never been greater. The link to our report is here if you haven't read it, and as Sir Andrew says, it's a real page turner. I commend it to you, and also there is the link there for the YouTube recording of the launch where he speaks. Mr. Justice Cobb, whom we've been working under, also speaks about the report, and so I hope you'll find perhaps an opportunity over a sandwich to just listen to the launch of that, and the link is there. Core recommendations. I will canter through these. The slides will be available. And of course, if you have questions as we go, I'm very happy to take them. But I think we all know in this area of the work that we simply cannot have the numbers of parents rushing to the court to deal with largely parenting issues. And we have made some core recommendations from our group. The group is comprised of 20 of us from a multidisciplinary background, and we have looked at the full range of services that are available and have some key recommendations. I think the first is a political recommendation. Families and family breakdown currently is spread across 13 departments of government. We are asking, as the Welsh Government has, for a families division and a minister whose brief includes children and families. We've gained some traction with parliamentarians. We're looking to have an event with parliamentarians, hopefully in the spring. And everything chimes, I think, with moving parents particularly away from the court space to another space. But we say we need a political lead. I think we need public education, a shift away from fault, which of course now with the divorce legislation we are moving towards. But I think reframing the language away from disputes, from justice, parents' rights, to one which promotes a better understanding of child welfare. And I think this must be the sort of mantra that in almost every case, of course, there will be exceptions and safeguarding issues, but in almost every case, a child has a right to have a full and loving relationship with both parents, and they have a right to be supported in that by the other parent. We are suggesting a separated families hub, one place which provides clear and accurate information, and also working on disseminating that to a number of other touch points, GPs, schools, health visitors, CABs, family hubs, so that they may similarly signpost families at the very earliest stage. we are looking at a framework of support for children and young people. If one sort of Googles, my parents are separating, my parents are arguing, that there is an array of information. Most children know about the NSPCC, but again, we are saying there should be a dedicated place within the hub for children and young people to be able to access information at an appropriate stage. We are also supporting the presumption that all children and young people aged 10 or above ought to be offered the opportunity to have their voices heard in the decisions that are being made for them. I think we all know, working in this area of the law, that when people present on marriage, family breakdown, they need perhaps a combination of services. There is, of course, legal advice, but we recognise that people need a holistic approach, an emotional support, and so we are looking at really a triage of services for families, so that there isn't the rush to the court for people to play out their emotions there, that there is perhaps mediation, legal support, and emotional support for those that require it. One of the key recommendations here, and I suppose we sit here now in 2022, and I've been practicing for a number of years, is that practitioners, legal professionals, can conduct children work without any training whatsoever in child development, neuroscience, psychology, how the way they practice may actually further fuel the anxieties and conflict rather than assist them. And so we are saying there should be mandatory training for all professionals that conduct children work, so that they are better placed to understand what their contributions may do in terms of the overall long-term health of a family. As illuminating as it was back in the day to learn about snails in ginger beer bottles, I very rarely found that comes into my daily practice. It must be right that professionals are properly trained in these areas, and that is one of our recommendations. Parenting programs. I was fortunate when I was a director of Resolution to work with James Peary and others. We created Parenting After Parting, which led to, and I think many people still continue to use it, this resource, which is on the Resolution website, updated by the now Parenting After Parting committee. Very pleased to have Christina McGee, who came over from the States to assist us in the therapeutic material there. And of course, then government developed the SPIP on the back of that work that we did. We are recommending that there are kite-marked parenting programs, and that they are mandatory for those that make an application to court. Of course, we want that resource to be available to people before they get anywhere near the court. But those, we feel, should be available to all parents that require them. And quite frankly, I think the state should pay for that. Language, we have a responsibility as lawyers in terms of the language we use. Again, this cultural shift away from legal disputes to a language which supports parents to resolve issues together. And there's some work which I can come on to here in terms of people looking at the language that we use. Family professionals, as I've said, the language we use, the services that we refer our clients to, the training that we may need to have, and I feel it is coming, professional obligations to comply with the Law Society's Family Law Protocol. I think it will become increasingly uncomfortable for family law professionals that conduct themselves in a way which does not look at the holistic needs of a family, and particularly the welfare of the children. And I can speak more to that as we develop. We are looking to develop networks of family professionals. And again, we've done some work behind the scenes in terms of what those might look like, perhaps county by county, so that everyone who does this work is there if people need counselling support, divorce coaching, etc., etc. It's all in one go-to place so that professionals know how to refer one to the other, again, to provide that holistic service that a family may need. My particular contribution here was in part the interface with the family court. We have rules that exist to promote the diversion of cases to the out of court space, but they are not being followed in many family courts or by many or by all practitioners. We are recommending that there is training for family judges, magistrates and legal advisors on the MIAM, proper enforcement of the MIAM by the judges and the court staff. We can talk more about that. Proper and robust judicial management by family judges in compliance with their duty to consider out-of-court options. And my particular contribution to this was the proposal of a new Part 3 protocol, and how that has gained traction since this report. I was invited to join the FSG really because I had been working on a Part 3 protocol. Mr. Justice Cobb was made aware of it, and so I was fast-tracked on to the group. We have, I'll come to this in a minute if I may, the family solutions. We recognise that there are two pathways effectively: the safety pathway for those cases where safeguarding is an issue and where the court will need to be involved for protection, and the cooperative parenting pathway, which is where I think many of these families and parents could be, which is nowhere near the court. The state is not there as the third parent, but we do recognise that an out-of-court solution is not the solution for all families. If those families that can move from the court space do move from it, the precious resources of the state will then be there more readily for those that need them. Again, just making the point that there is this distinction in private law cases between those that require state intervention and those that largely don't. Safeguarding, again, as I've worked with this idea of moving cases from the court system, many people have said cases of domestic abuse, Practice Direction 12J, recent authorities, etc., that cases aren't suitable to be moved from the court space. We absolutely accept that. I put this in the notes just for completeness, but where there are not those considerations, we really think court should be the forum of absolute last resort. So moving, sorry, as I quickly did there, I hope I'm not making you giddy with the moving through the slides. I'll move to effectively where I've come in on this, which is the pre and out of court space, and effectively, I think a new approach to the way in which largely private children matters are dealt with. I haven't practiced at the coalface like many of you for a number of years. I sit on Resolutions Dispute Resolution Committee, and I'm grateful to Angela Lake Carroll for this stairway of opportunities, which I put here and is in the FSG report, because it does highlight the full range of out-of-court processes, starting from sort of DIY options, moving all the way up to judicial determination. And it seems to me, I think, operating in the out-of-court space, and certainly since the pandemic, that the range of out-of-court processes has become more sophisticated. And yet, notwithstanding a hugely sophisticated range of processes, people are still clinging to the court. I mentioned earlier the move towards sort of different language. There is the Family Law Language Project, which is now up and running. The link is here. Again, in a multicultural and international society, we've got to be thinking about how what we do serves all members of society. We need to take responsibility for the language generally that we use. And again, that project is looking at some of that. The link is here for further information. So we have a range of processes. Again, since the pandemic, it seems to me that because we've had no other way of working, that our range of processes has increased and become even more sophisticated. I am one of 12 parenting coordinators in the country. I mention that because that process is there for parents that have got their final parenting plan or their final court order, but cannot be expected to go off and implement and co-parent without some sort of assistance. I'm doing the training with the FLIP faculty. We've got another round of training in the spring and into the summer for anyone who may be interested in learning about becoming a parenting coordinator. Please do contact me. But essentially, it's an American process, which is now over here. A PC is appointed to a family, typically for a year, 2 years. They assist the parents in interpreting and implementing the final court order, mediating issues as they arise. But if there are issues which cannot be resolved, the PC makes a determination. We've seen the work of the divorce surgery, and I have to tell you that I think the one lawyer, 2 clients is coming. Again, I'm on a working group with Resolution in terms of future practice. We have looked at a model. We think we are virtually there. We've seen some models develop. Simpson Miller are currently using this. Withers Uncouple, 2 clients, 1 professional. I think this is the direction of travel. It may not suit all cases, of course, but perhaps that's something that I can do another seminar on at another time if I'm invited back to explain what this model might look like. It's definitely coming. As I say, it may not be for all practitioners and it may not be for all cases. We've seen the Certainty Project, which takes a case from beginning to end with an adjudication and arbitration if required. Hybrid mediation, where lawyers are in the meetings. That's been very, very popular, certainly since the pandemic, and we've increased the number of hybrid practitioners. Blended mediation, where perhaps some people are on the tech and others are in the room. We've had mediation by entirely separate meetings, where perhaps behaviours, history, safety issues, high emotions, I mean, it is just unwise or unsafe for people to be in the same vicinity as one another. And we've seen, obviously, therapeutic interventions in complex children cases, where obviously the court is not the right place for many of these families. So a whole range of processes which are becoming more sophisticated, and yet we still have too many people clinging to the court system. So what I did, and I think I'm now into 3 years ago this summer, I thought, look, we've got part 3 of the family procedure rules. Why is it that I think it's just gathering dust on a shelf somewhere and it's not being used? So I reminded myself of actually what the court's duties and powers are under part 3. And I put them here just for ease of reference. The court's duty and power to encourage and facilitate the use of non-court DR. The court's duty to consider non-court DR. The court must, this isn't a should, it is a must. The court must at every stage in the proceedings inquire as to whether it's taken place, whether a MIAM has taken place or there's a MIAM exemption. What can the court do? Well, the court can adjourn the proceedings if it considers that non-court DR is appropriate, and it may direct that a case is adjourned for people to go off and find out a bit more. The court may give directions under this rule on an application or its own initiative, etc., etc. It can't compel people to go, although I do have some thoughts as to what we might do there. So in summary, the court's existing duties and powers is to inquire, has non-court DR been considered? Has it taken place? What was the outcome? The court can stay the proceedings for parties to find out more and to hopefully engage. The court can make an UNGLI order. I think this is very rarely used. I think it should be used a lot more. the court can make an Ungley order after the Chancery Master Ungley in a case of man and man, where if a party says a case is not suitable for ADR, they must file a statement no less than 28 days before the final hearing, stating why they think it was unsuitable for an out-of-court process. And those will be considered after the final hearing, and costs made if the court takes the view that actually it was suitable for ADR, non-court dispute resolution. And so I would say to you, think about asking the court to make Ungley orders and remind yourself that they exist. And of course, the court can make cost sanctions, and I'm going to move to that in a little more detail. I developed the Part 3 protocol as the Surrey Initiative, the objective being to start to use some of these out-of-court processes to harness the skills of family law professionals and others. It wasn't and isn't about leaving professionals behind. It is about using the professional skills perhaps in a different space and in a different way, hopefully leading to better experiences for separating and divorcing families, improved outcomes for families, particularly children, and certainly to ease the burden on the court system, leaving the precious resources of the state for those cases that genuinely need them. And I thought I would do this by putting Part 3 front and centre, the obligation to apply to the participants, the parties, the lawyers, and the court with evidence that Part 3 has been considered. I have put the link here to the now developed Family Solutions Initiative. At the Surrey Initiative stage, I thought I probably need to bring in some heavyweights to assist me. And so I was delighted that Rhys Taylor of the 36 Group and Martin Kingley QC, looking at matters through the children lens, were only too pleased to join this endeavour. And we have created the Family Solutions Initiative, and the link is here. It is on family law. It is not behind the paywall. So if you put this link in, you will there have access to the full article, the suggested precedent letters, etc. And I would say that if you are writing letters in accordance with the proposed protocol or the initiative, it is to actually put that at the bottom of your letter so that colleagues in other towns and jurisdictions, etc., can start to see what you're doing. We had a question in advance from a colleague who'd had some correspondence with colleagues in Solihull, and they said they'd never heard of it. Well, people are using this. Flip were very, very quick to jump on this and said, if we don't start to change the way in which we consider out-of-court processes, if we don't start to change the way in which we write to our professional colleagues and opponents, people are leaving themselves exposed to cost orders. So I would say read the article, think about how you might adapt the precedent letters, but certainly endorse your correspondence with, if you feel you can, we support the endeavours of the Family Solutions Initiative. This letter is written in accordance with it, and put the link so that people are aware of it. People are using it. They are changing the way in which they write to one another. And I'm grateful for the question in advance, but I'm disappointed that some of this perhaps hasn't reached Solihull. So what does it say? It is intended to apply to financial remedy and children cases. It requires practitioners to invite their professional colleague, opponent, to consider an out-of-court process. The letters should be open so that they can be shown to the court, and they should set out, dear so-and-so, we think this case is suitable for whatever process. It should set out perhaps when and how that might take place, how it might be funded. We invite you to comment on that. This letter is written in accordance with the initiative, and we shall be inviting the court to consider it when making its directions and considering the issue of costs. If you receive that sort of letter, I would suggest that you respond to it within 14 days, again in open terms, and accept that it could be shown to the court. And if you need some additional time or feel that you'd like to suggest some other out-of-court process, then please do so, or why you think perhaps at that particular time the case is not suitable. So what we have tried to do here is to put Part 3 front and centre. I feel actually practitioners, and there's no harm in doing this, could put in their correspondence, and a copy of this letter has been sent to our client. I think the barristers, Rees and Martin, assumed that all good solicitors, lawyers would forward copy correspondence to their clients. Perhaps some do, some don't. And so we've sort of moved away from a certification that, you know, I certify that this has been sent to my client, but I think it's good practice to say, and I've sent a copy of this letter to my client and shall be sending a copy of your response. You won't be able to read this here, but it does highlight the draft sample correspondence, which of course people will amend in their own way, and it includes finance and children cases, and if you're writing to a professional colleague, or adapted if you're writing to a litigant in person. So must be in writing, must set out the rationale, do expect the court to be told of the contents or eyelash the chain of correspondence. The proposed Part 3 protocol is one of the recommendations of the Family Solutions Group, as I say, and it is already gaining traction and changing the way that people are practicing. Do expect an awareness and support for this initiative. Do familiarise yourself with the sophisticated range of out-of-court options, both within and outside of your local court area. Do expect judicial encouragement for the parties to engage and inquire in out-of-court processes, and do expect, I think, a more robust handling by the courts of any practical arrangements that may need to be made, inquiring as to how we're going to be funding these issues, who's the choice of professional, if it's a private FDR, etc., and drug-free. And of course, since I've been on this endeavour, and I suspect you're all groaning from the latest practice and final remedies court, but we can see, can't we, that the focus is absolutely there will be penalties and sanctions for people that do not negotiate openly and reasonably, and I think we can expect increased sanctions for those that do not engage in out-of-court processes appropriately. Expect the court to want to see the Part 3 communications, and do expect, I think I call them judicial rollickings, perhaps if people have failed to respond to an invitation, have unreasonably refused, or just say, well, we don't know how to find mediators or a private FDR adjudicator, etc. And I think to expect an increased use of UNGLI orders. As I've taken this around, of course, people have said the safeguarding issues, I get that. Will it create a two-tier system between those that can afford an out-of-court process and those that can't? I'm highly sensitive to that. I have some ideas there. We were working with His Honour Judge Hess, who is looking at financial remedies, and Rees Taylor, in terms of weaving this into the financial remedies court good practice protocol. The existing protocol of, I think it's November 2019, is still the relevant protocol, but certainly whether the case is big or small, there is an obligation to negotiate reasonably and openly, and I think to negotiate also in an out-of-court process. The direction of judicial decisions, what am I doing for time? We've had these cases which I've listed here, which I think are important, and I've also listed just bringing together some cases in terms of the direction of travel in terms of cost orders. I think in the case, in Stephen Wildblood's case, on the Judge Wildblood in Re B, I think, having spoken to him and reading the judgment, that he must have come very, very close, I think, to making a cost order. And I think against the solicitor, I have to say. He's made it quite clear, do not bring your private law litigation to the family court here in Bristol unless it's genuinely necessary for you to do so. You should settle your differences or those of your clients. He's really speaking to the lawyers here, away from the court unless that's not possible. If you do bring unnecessary cases to this court, you will be criticised and sanctions may be imposed against you. There are many other ways to settle disagreements, such as mediation. Message here, folks, I think is, as practitioners, you must evidence on your files that you have discussed at all times, not just at the beginning, but constantly throughout the conduct of a matter, that you are considering out-of-court processes with your clients. You should not rush to court unless, particularly on private children law matters, it is genuinely necessary for you to do so. I think we're probably very near to a practitioner having a costs order made against them, and that, I think, will then be the game changer. Mostyn in JB and DB had directed that, encourage the parties to get to mediation on a long-running financial case. The husband had willfully refused, I think, pulling out of a mediation the day before he made a £15,000 costs order against him. I have been delighted and pleased and honoured to have been supported in this endeavour by Nick Allen, QC. And actually, he'd said from the get-go, I think that you're onto something here. I really think there is something in this. And I've now had the first reported case on these endeavours. I put it here, a dispute about nanny costs, not proportionate to take up the court's time. He's recited the relevant parts of Part 3. He's reminded himself of his powers and duties. He adjourned the case. He lent on them, I think, pretty heavily to get into mediation. They did. They resolved everything, I think, but one item. He asked for short submissions on paper. He made a decision. He spoke to Mr. Justice Mostyn about the case, and he asked him to report the case, which is here. And I think it's a useful case, again, when you are in correspondence with professional colleagues, that you can ask the court to adjourn, you can ask the court to try and encourage into an out-of-court process. And actually, I've used the case as evidence of how Part 3 and this initiative should be used. Again, just reminders here that if there are even discrete points, wording of a draft letter which couldn't be decided, think about putting that to an arbitrator. Mr. Justice Moore in CM and CM 2019 case, High Court judges are extremely busy. Please don't trouble us if there are other ways to find a solution. I put here the trend in the court making costs orders, particularly where there's been a failure to negotiate openly and reasonably. We absolutely are going to see more of those. There cannot be any doubt, particularly in line with last month's financial remedies programme, which has been put together. So I suppose, are we at the point here where we actually need an FPR rule change for compulsory out-of-court use? Personally, I think we are. I don't think the Article 6 objection stands anymore. It's been looked at. I think if Halsey fell for redetermination, the decision would be that it would not offend Article 6 rights for the court to order mediation. I think the low-hanging fruit could start perhaps in finance cases, with the court being able to order to a private, properly constituted private FDR or arbitration. I've put figures here for the arbitration figures. I can update those as at November. Since the commencement of the finance case, arbitration scheme, in total, this is not a yearly figure, but the total number of finance arbitrations is 424. And since the commencement of the children's scheme in 2016, 51 children arbitrations. Not enough. We need to find a way to obviously, I think, remove whatever the blockers are to people using arbitration. And I've put here for anybody who wants to do any further reading about where I think the thrust is coming from, and certainly in terms of the civil elements, the move towards compulsory mediation. I've put here the link to Dominic Raab, November, cost orders for parents clogging up the family court. If you haven't read it, I'd suggest you do. And I'm putting here, I suppose, a sort of call to arms for those that might be interested in joining this endeavour. What we are looking to do on the Family Solutions Group is to have a national network of services, but with each county having, as I say, its website where all services could be found and where professionals can signpost and cross-refer. And Kent has already beaten us to it. They've set up theirs here. I'd say have a look at it. If you might be interested in joining the cause in terms of establishing this for Surrey, please let me know, because we're looking to have a similar website for all services to be listed in our geographical area. So do express interest. We are looking for consistency then across the country. And I have to tell you that link therefore, that Kent resource is now listed on every order that is made in Kent, which I think is really interesting. The future, we cannot move, particularly private law, children matters, it seems to me, from the largely state-funded arena to a private arena, which may be mediation or other non-court processes, unless there's funding. There has been an extension to the voucher system to 3.3 million, provides £500 towards the cost of private law children mediation. The data so far is good. 77% of cases that have used the scheme have reported a whole or significant resolution of the issues. And it's interesting, actually, since the commencement of the scheme, that the number of private law applications has fallen by, in September, 17%. Again, there are links for those that may be interested in the data about who is coming to court, particularly on private children law matters, and the research there from the Nuffield Family Justice Observatory, that they are much more likely to be those from lower socio-economic grounds. Well, of course, it means there needs to be funding for people to stay away from the court, and we cannot move them from the court system unless there is funding. Personally, and I've put this into the MOJ in its call for evidence, I think to deal with the backlog in terms of private FDRs and final hearings, I've suggested there is a voucher scheme, maybe £1,000 a case, I don't know, but a voucher scheme that would persuade people to move their matter from the court space to perhaps a private FDR or to an arbitral outcome. Where are we with children? Well, I feel, I really feel that everything is pointing towards some sort of mandatory requirement to attend mediation, if not called mediation, because we know part of the essence of that is that it's voluntary. But could it be called, for example, as it is in Sydney, Australia, family dispute resolution, where there it is compulsory, it is mandatory, except in cases of extreme urgency, domestic abuse, domestic violence. The parents are required to work with a family dispute resolution professional. It's compulsory. People who otherwise would make an application to the court now cannot do so unless they have worked with that professional. Again, I have made that recommendation in the call for evidence. Let's wait and see. It will need some money, as I've said. So next steps, I think much better MIAM enforcement. I think part 3, front and centre, much more robust case management by the judges, including adjournments, UNGLI orders, COS orders, a network across every region across the country in terms of signposting, joined up services, etc. It'd be great to have in Surrey all court orders endorsed with that link. For professionals, I think you need to be thinking about how you currently practice. You need to appraise yourself of all the non-court options available. You may want to consider training in some of these. I would say, wouldn't I, that Resolution has, fantastic training. It's got fantastic tools for professionals in terms of how to use a non-court process, how to train in one, etc. I think there is going to be some sort of move to mandatory attendance, perhaps family dispute resolution professional, even if it's not called mediation. And I think it may just start to get more uncomfortable for those professionals that do not evidence at all stages of their case consideration of an out-of-court pathway. If they don't suggest it to professional colleagues, and if they unreasonably refuse to engage, I think things could start to become quite uncomfortable. Okay, that was a very quick canter through. I hope I still have you all here, and I'm very happy to take questions.
There's no questions in the chat at the moment, Karen, but I'm sure if Helen was to say that we could open the mics up to anybody who wants to ask a question in person, then that would be fine.
Absolutely. Now I'm looking at the attendees here, and I suppose I could always ask people if they're happy to let me know whether they feel in our geographical area there has been a greater focus on out-of-court processes, whether they feel that is shared with their professional colleagues, obviously without naming names, where perhaps some people feel there are points of resistance, or where it's a tougher nut to crack. But it would be really helpful, I think, for me to get a sense of, certainly in Surrey, what the sense is about using the court as a form of absolute last resort, unless of course you need a timetable, and is there a greater take up of the out of court processes? And I suppose if someone doesn't jump in with a question, I could just pick on someone. I can see there are a few colleagues at my firm. So, some sort of sense in Surrey of, are we perhaps trailblazing? We've got a really good selection, I think, of out-of-court practitioners. Do we have enough? Is there still a resistance? Are costs an issue? Do the processes have rigor? Do they work? Well, I think they do. What is it as a county that we might think about in terms of what we're doing well, where we might be able to perhaps raise our game?
Can you hear me, Karen?
I can. Nicola, how lovely to know that I'm not just speaking into the darkness.
Into the void. Sorry, I raised a hand. I wasn't quite sure if that happened. Yeah, I just wanted to say that I think in Surrey, we have been very much more aware of the other options available, and I can't remember the last time we issued, unless it was absolutely a case of last resort. So we have been using your precedent letters adapted suitably, and that's worked well. I was the one that put in that that query because as has happened quite a lot in the pandemic, I had a case that was a little bit off patch with a solicitor in Solihull. So I was making the usual sensible suggestions about not going to court. We had got almost to the end of quite complex financial remedy negotiations, and there was just basically 1 point left over complicated pensions. So evidently it was a case where court would be a sledgehammer to crack a nut. So I had made the usual noises that if we had an impasse, private FDR, arbitration, roundtable meeting, anything, and I just the response I got back was, well, why would we try that? It might not work. Which is why I want to ask the question, has this been sort of equally deployed and publicised across the country? Because quite clearly my counterpart had not heard or even if she had heard of it, she hadn't embraced it. So it's encouraging to note that it should be rolled out everywhere. Just slightly disappointing in that situation that we were still being faced with the same, threat that, well, it's my way or the highway.
Okay, thank you, Nicola. Thank you for the question in advance. I've heard of Solihull. I think I've been through it on the way to a football match somewhere. I think it's like many things. What is it that makes people do what they need to do? Fear, I think, can be. I have absolutely no doubt that if a practitioner has their feet held to the fire, and it becomes very, very uncomfortable, and particularly if that's then reported even on an anonymized basis, and I'm not looking for the world to become more difficult for practitioners. Our jobs are very, very difficult, but we are failing families if you have to bring out a sledgehammer to crack a nut. So I'm grateful to you. I know that you've been using the precedent letters, and they are there. And, there have been some reactions to the letters as they appear on the Family Solutions Initiative that perhaps, they appear sort of a little too feisty at the beginning. Everyone can adapt them to their own suitability. But the point is this. I think one has to write to professional colleagues and say, we have an obligation. I remind myself of part 3. I have read about this and am using this initiative in my work. And I'm proposing the following processes. I invite your response within 7-14 days, explaining whether you feel we should do this or offer an alternative process and your rationale. But please be advised that I will be showing the court this correspondence, and I will be inviting the court to use its part 3 powers and duties in relation to this issue. I think I would also say this. I've asked for a new paragraph G for FPR 28.3 bracketed 7. And I think Nick Allen's view is, Karen, I don't think we actually need it, because the court, when deciding what cost orders to make, can have regard to a party's unreasonable refusal to engage in non-court DR. He said, I think actually if you've got the subsection G, it really makes the point, but he feels the court has already got those powers. So, I'm disappointed by our colleague and friend's response from Solihull. Like most things, I suppose, and the financial remedies information which has come out in the last couple of weeks, people will have to adapt. They will have to demonstrate that they have negotiated openly. The court is not saying that it should reach into without prejudice content, but the court is saying that you should negotiate openly and reasonably, and you should engage in an out-of-court process. And I think if you can't demonstrate those two things, I think it's going to become increasingly uncomfortable for practitioners. I think there's a look at, both for barristers and solicitors, a look currently going on in terms of the disciplinary aspects of that. I don't mean to frighten people here, but these issues are not going to go away. So I'd say continue to do what you're doing, issue as absolute last resort, continue to write appropriately and in your own house style those letters. It's changing the way I'm told people are doing their business in London and in other pockets. I hope some of this eventually reaches Solihull and the other parts. Any other experiences of those that have used the correspondence, and perhaps responses they've had from other Surrey practitioners and those from out of area? I can see there's one hand. Nicola, I don't know if that's still your hand.
No, it's mine, Karen. Can you hear me?
Hi, Jo. I can. Hi.
It was, very much just following on from what Nicola said. I had quite a similar experience actually, but with a firm in Bristol this time, and we got to the end of quite complicated financial remedy disclosure, and we were a bit stuck, and I was suggesting a private FDR among other things, and they kept pushing me on why not just issue, why not the court system, and I was explaining the certainty of choosing your judge and having more control and timing, all the reasons we would normally put. And I kept getting back from them, oh, but the judges are so good in Bristol, like we'll have just as much certainty. We don't need to go out the court system. And that was their set response, interestingly enough. Ultimately, they did agree to a private FDR. We were able to settle, but I just thought that was quite an unusual and interesting approach. And it's not the sort of experience we have with the judges in Guildford always, I'm afraid to say.
It does surprise me in Bristol because, I think that was a geographical area that was mediating much earlier than, many other areas. It also surprises me knowing that His Honour Judge Wildblood QC sits in Bristol. And, again, I know that the Re-B decision was private law children matters. But, I think the message must follow that court is the absolute place of last resort. Of course, we know now that a properly constituted private FDR can take place in substitution for the court mandated. I suppose the reasons would be, one, we've got an obligation to try and resolve this for our clients. Two, the time it takes to get to a court date requires funding. I know as you need to maintain a case, even if it's going on in the background, that takes an enormous amount of money. It's pushing a solution further away, whereas there's the potential for it to be resolved sooner. I think that although, the judges are fantastic in Bristol, etc., the court may take a dim view that this is before the court when it could have been dealt with in a private FDR. And I think, part 3 again. And if it gets to the point where we've got to make representations in terms of the costs for maintaining the case to the court FDR, and pushing away a solution, rather than getting one sooner, I think you've got to ask them to say that we reserve the right to show this to the court on the question of costs. I'm glad they took up the private FDR, and of course, private FDR's work. I hope it worked in that Bristol case. Did it, Jo?
Yes, it did. We were able to settle it. Yeah.
Okay. So why do it? Well, it works, and of course, there are all the other aforementioned benefits. Thank you. Somebody's come in on the chat. NR. I'm sorry, I don't know who that is. Okay, I'm going to try and quickly. Nikki, thank you. I think if there was a case reporting on cost sanctions that other practice, I can absolutely agree with you. Continuing Joe's comment, although I'm in the Midlands, you're most welcome. I have come across those professionals in minutes that are very much of the opinion that once it's gone to court, we leave it in the court. As you explained, we need to suggest out of court at every point. They're not aware, and that's bizarre. It is bizarre. I think I'd go back and reread part 3. And I think quote part 3. And, there is no doubt it's not that the court should, the court must, and the court must inquire and test part 3 at every touch point with the court. And I think you've just got to go ahead and quote that. I think where there are cost cases that are useful to any particular argument that you make, I think you make them. And I would say to people, please feel free to cut and paste the link to the Family Solutions Initiative. I just put it here. It's in the slides, which will be coming to you via Helen. It is put that at the bottom of your letters, and people can then look at it. As I say, it's not behind the paywall, because we said we wanted it to go somewhere where people could access it. Put it on your correspondence. If people start reading it, get out into your judges and make them aware of it. I've gone around the country with various of these presentations, and the judges have said, yes, please, more of this. In fact, I can tell you that many of them said, if only we could order into mediation. Well, there's a thing. That's perhaps stage 2 of my endeavours. But it is changing the way that people are practicing. And let's be honest, there isn't going to be more money thrown at the court system. I do think there needs to be money put towards people taking their private law children matters away from court to somewhere else. Everything, as I say, on the voucher system for the mediation scheme so far suggests mediation works. We know it works. It can't work for everyone. But I think that, government has got to accept that it's got to put some money to this. Otherwise, we're not going to move people from, as I say, the state system, the court, to an out of court process. But it would not surprise me if we've got some sort of mandatory mediation, something by another name, or as I would quite like to see, the court having the ability with a rule change to order into a private FTR or arbitration. Now, I'm mindful.
Karen, we've tripped over the hour, but if you're still happy to answer questions and stay on for a little bit longer, that's fine. But I know that everybody's time is so valuable at the moment. But if you are happy to just answer any more questions if they come in the next few seconds, then that'd be great.
Yeah, thank you. I'm very happy to, and I'm very happy to have conversations after this. I hope when the slides came, and I'm sorry, some of that was a quick canter, but I really wanted to have this bit of a discussion about what the landscape is like in Surrey, which I think I know, how we might try and persuade some practitioners, which perhaps their default process is issue, what we might do perhaps to encourage the courts, our judges, to say, yes, I'm aware of this, which they are, this initiative. I am going to actually exercise my Part 3 duties and powers. And I'd say, Nick Allen's most helpful case, which is now reported, again, I think with practitioners and the court, is just to remind everyone of actually what the court can do if a case is issued. But what we're really trying to do is get people before they issue, and even after they've issued, try and get them out of the system. Is there, Nikki again, thank you. Definitely something I'd quote, Part 3. I'm in Surrey. Midlands are running cases completely differently. Judges in Midlands are very close on giving out costs. Are they? Okay, thank you for that, Nikki. Obviously, I met Martin Kingley QC. I went up to speak to the Leicester Family Justice Board. The judges there went terrific. More, please, more, please. Can you try and get some sort of court, an FPR rule change for court mandated ADR? But very interesting there, Nikki. Thank you. Judges in Midlands are very close on cost sanctions for professionals. Well, you've heard it there, folks. I think it's coming. That's Leicester. Okay. I think it's coming. I would not want it to be anyone within our community. I don't want it to be anyone, but I think we're getting very dangerously near for a cost order to be made against a professional, and I suspect that will be game changing. Okay, I hope this was helpful. As I said, it was a real canter.
I think we've run out of questions, and I just would like to thank you, Karen, so much for what was an absolutely brilliant talk and delivered with such authority, which is testament to your win of the Family Lawyer of the Year at the Surrey Law Society Awards in 2021, and I'm sure that's well reflected with everybody on the call today. If the session has been recorded, so a link will be sent to everybody if you need to just dip back into it at any time. Please, if you can, pass any feedback back to either Karen or Helen at Surrey Law Society. It's invaluable for us to be able to sort of develop and build programs on subjects which are of interest to everybody. So the feedback will certainly help us with that. I think that just about brings it to a close. Thank you very much for coming to today's session. Thank you, Karen, once again. Thank you, Helen, for arranging it all. And I'm sure we'll see each other back in Guildford and on the circuit in due course. See you soon. Bye-bye.
Bye.